I never imagined that a simple request to paint my front door navy blue would spiral into a full-blown legal battle with the president of our homeowners association. Yet that's exactly where I found myself after clashing with Karen Wilkins, the self-appointed gatekeeper of Oakwood Estates, and the most intimidating figure in the neighborhood. It all began last spring when I decided to give my home's exterior a small refresh. Before lifting a paintbrush, I carefully reviewed the HOA guidelines. The rules allowed tasteful, subdued colors that match the home's overall appearance, but they didn't specify which shades were acceptable or prohibited. Confident that my choice fit the criteria, I picked a classic navy blue that complemented my shutters, attached paint samples, and submitted the form. 3 days later, an email landed in my inbox from Karen with a subject line typed entirely in capitals. Violation notice. Unauthorized color selection. According to her, my navy door was excessively bold and disrupted neighborhood aesthetic harmony. She demanded I pick a color from the so-called approved palette, which, unsurprisingly, consisted only of beige and pale gray. When I pointed out, politely, that no such list existed in the official documents, her curt reply was, "The board has discretionary authority on aesthetic matters. Your request is denied." Not being the type to bow to arbitrary authority, I asked for a formal hearing. That's when the situation turned even stranger. The hearing was postponed twice under flimsy excuses, and when it finally took place, Karen produced what she claimed was an amended bylaw proving bright colors had been banned for 5 years. The paper looked suspicious. The font shifted halfway through, and the page with the supposed restriction was crisp white while the rest of the document was clearly aged. After my request was denied, I began digging. I tracked down the HOA's former president, now retired in Florida, and asked about the amendment. He was baffled. "We never passed anything like that," he told me. In fact, we deliberately decided against color restrictions because nobody could agree on what should be allowed. Armed with this, I went to the county records office where all HOA documents must legally be filed. Sure enough, Karen's amendment didn't exist. The only valid covenant mentioned nothing more than the vague requirement of tasteful and complementary colors. When I confronted 2 other board members, they squirmed but insisted Karen must have the right version. One even muttered nervously, "She's very organized with paperwork. Maybe she just hasn't filed the amendments yet." Unconvinced, I sent a formal letter demanding clarification. 3 days later, I came home to a certified letter from the HOA, written by Karen herself. Inside was a $900 fine for alleged violations, trash bins, improperly placed, unauthorized stone borders in my garden, and even excessive holiday decorations in April, when I had none at all. It was blatant retaliation. I photographed my spotless yard as proof and requested another hearing. Instead of responding reasonably, Karen escalated further, filing for an injunction against me. In her complaint, she accused me of harassing the board and disrupting HOA operations. To make matters worse, she attached an affidavit supposedly signed by my next-door neighbors, the Johnsons, swearing to my aggressive behavior. But I knew instantly something was wrong. The Johnsons were on a 3-week European cruise at the time the document was dated. When I called them, they were furious that their names had been used without permission. That's when I realized this wasn't just HOA overreach anymore, it was fraud. I met with an attorney who specialized in HOA disputes, and her reaction said it all. "This goes beyond policy issues," she told me gravely. "Forgery and falsified legal documents are criminal matters. We're taking this to court." Together, we filed a countersuit against both the HOA and Karen personally, supported by all the evidence I had gathered. The case landed in front of Judge Marcus Rivera, a man with a reputation for cutting through nonsense in record time. He wasted no time scheduling. The court scheduled an emergency hearing to address the forgery allegations before considering the original injunction request. On the day of the hearing, my nerves were on edge as I stepped into the courtroom. Across from me sat Karen, impeccably dressed in a tailored suit, her posture exuding confidence. She barely acknowledged my presence. Keeping her attention on the neatly stacked papers she and her attorney, a slick-looking man in an expensive suit, were arranging. Once Judge Rivera entered, proceedings began. Karen's attorney launched into their case first, portraying me as a disruptive homeowner unwilling to follow established rules. He dramatically waived the suspiciously amended bylaws as proof of my alleged misconduct. When it was our turn, my attorney calmly laid out the truth. Official county records, sworn statements from the former HOA president, and most damaging of all, an affidavit from the Johnsons stating they had never signed the documents Karen had submitted. They even provided evidence they were out of town at the time the signatures were supposedly collected. As Judge Rivera compared the signatures against official records, his expression hardened. "These signatures don't even resemble the Johnsons' verified signatures," he remarked, peering over his glasses at Karen, who had begun to fidget uneasily. "Ms. Wilkins, did you personally witness these documents being signed?" Karen's composure cracked. Clearing her throat, she answered, "I received them by email, Your Honor. I printed them out for submission." The judge immediately requested to see the emails. After her attorney whispered frantically in her ear, Karen fumbled with her phone before claiming she couldn't locate them. The judge's displeasure was obvious. "And what about these supposed HOA amendments?" he pressed, holding up the questionable pages. "The county has no record of them, yet you've been enforcing them as binding." Karen's reply was a rambling excuse about administrative delays and paperwork backlogs, but Judge Rivera cut her off. "This court views document falsification as extremely serious. Ms. Wilkins, I am ordering a forensic examination of every document you've submitted." Karen's face drained of color. Her attorney quickly asked for a recess, which was granted. 30 minutes later, we reconvened, and it was obvious her confidence had vanished. She now sat whispering anxiously to her lawyer, her earlier bravado gone. The forensic examiner's findings were decisive. The amended bylaws had been printed recently, not 5 years ago as claimed. The paper stock didn't match the rest of the records. Worst of all, digital analysis showed the Johnsons' signatures had been lifted from old HOA membership forms and electronically pasted onto the affidavit. Judge Rivera had heard enough. His voice rang through the silent courtroom. "Ms. Wilkins, stand." Karen rose shakily, her eyes darting as if searching for escape. "Based on today's evidence, I am dismissing the injunction against the defendant. Furthermore, I am referring this matter to the district attorney for investigation into document fraud, forgery, and perjury. Bailiff, take Ms. Wilkins into custody." A collective gasp rippled through the courtroom. Frozen in disbelief, Karen sputtered, "This is ridiculous. I am the president of the Oakwood Estates HOA. You can't treat me like a criminal." Judge Rivera remained unmoved. "The law applies to everyone, Ms. Wilkins, regardless of their title in a homeowners association." As the bailiff escorted her away in handcuffs, Karen broke down weeping, mascara streaking her face. Still, she managed one last defiant glance over her shoulder. "This isn't over," she cried. "I've given everything to this neighborhood." The judge set her bail at $25,000 and ordered her to surrender her passport pending trial on multiple felony charges. Then he turned to me directly. "Sir, you are free to paint your door any color you like under the actual HOA covenants. And I strongly suggest the remaining board members hold an emergency election to replace their leadership." When his gavel struck, finalizing the hearing, I felt an immense weight lift from my shoulders, one I hadn't realized I had been carrying for so long.